a day that will do a lot of good work today, I think, and that'll be the same this week. So the first thing we're going to do is hopefully you all had a chance to look at the minutes for January 13th, 14th, and 15th. We're going to go ahead and approve those. Do I have a motion to approve those minutes? Representative Osmond.
Thank you very much, Madam Chair. I make a motion to approve the minutes that have been that have been stated.
Okay, second by Representative Lewis. Okay, any objections? All those in favor say aye. Okay, thank you. Then those minutes are approved. Okay, we are just going to go right on. The plan today is to go ahead and hear 3 bills, and then we're going to work bills after that. We do have some committee members that are testifying or not able to be here right now. I like them to be here when we work bills. So that's why we're going to hear bills first. So with that, we will go ahead and open the hearing on House Bill 2521 and ask our revisor, Jason, to please give us a bill brief on that.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So you have House Bill 2521, which expands the Kansas Tort Claims Act to include child placement agencies that contract with the Secretary for Children and Families. The amendment is to KSA 75-6102, which is the definition section of the Kansas Tort Claims Act. You'll note that under current law in subsection A, state means the state of Kansas and any department or branch of state government or any agency, authority, institution, or other instrumentality thereof. And the bill adds there in lines 12 through 14 that state also means, under the bill, a child placement agency as defined in KSA 65-503 if such agency has a current contract with the Secretary for Children and Families. So this would add those agencies with a contract to the definition of state for the purposes of the Tort Claims Act. And just because I know most of you don't have background in the Tort Claims Act, and I am not an expert on it, so I gave you a brief little 1-paragraph summary of the high points of the Tort Claims Act and the bill brief. Generally speaking, that act statutorily waives governmental immunity, and it allows tort claims against the state and local governmental entities subject to the limitations that are provided in the act. Specifically, some of those limitations are outlined in 75-6104, where either entities or employees acting within the scope of their duties are not liable for damages resulting from a list of about 24 different items. So there's a number of exceptions, but the main one is functions that are discretionary in nature. And so that's one of the major exceptions to the Tort Claims Act. But in essence, this act creates a framework for how you sue the state and waives the immunity that they otherwise have. And this would include the child placement agencies in that framework. And if I could defer to the conferees to maybe explain the why, I would appreciate that, because I'm hoping to find out a little bit more about that as well. So I'd be happy to answer any questions I can.
Okay, thank you. Do we have any? Yes, Representative Lewis, questions?
Thank you, Jason. So put aside for the moment how the bill's written. Do you understand the intention is for these agencies to be subject to the Kansas Tort Claims Act when they're performing the duties they're contracted to perform, or for anything they do?
Madam Chair, Representative, that's an interesting question. The way the Tort Claims Act is written, I think it generally has to be related to the duties they're performing, but we might need to dig into that a little bit more to see if this might go into areas they don't intend. I don't know that I have an answer off the top of my head, unfortunately.
The reason I ask is because my quick look-see is that it's not, as written, it doesn't seem to be restricted to the duties they're performing pursuant to contract.
And Madam Chair and Representative, that generally just being in the definition means that your agency could be considered the state, but then all of the exceptions and all of the liability comes with actions by you or your employees. And I think it's within the scope of those duties, but we should we should just make sure that it does exactly what they want. That's an excellent point.
Thank you.
Thank you. Do we have any other questions? Representative Carmichael.
Thank you, Madam Chair. Mr. Thompson, would this legislation then incorporate, if you will, the $500,000 limitation on liability that is provided for in the Kansas Tort Claims Act and transfer the responsibility for the payment of those damages from the private insurance companies where it lies now to the taxpayers of the state of Kansas?
Madam Chair, Representative, so to the second part of that question, I'm not sure, and I think the conferees can answer that one a little bit better. But the first part of the question, yes, it would be, these actions would be subject to the limitations on damages that are provided in the Act. I know there is an insurance exception to that limitation, so if there's insurance involved, it can exceed that amount. But now we're hitting the edge of my knowledge of the Tort Claims Act, and so I'll just stop there before I say something that's incorrect.
Thank you for your help.
You're welcome.
Okay, any other questions? Okay, thank you, Jason. Appreciate that. Okay, committee, we're going to go a little bit different than in the order that we have. I am going to limit the testimony to 2 minutes. And so please, what I would ask is that you don't read your testimony, but you really give us the high points. That's what we want to hear. And then you can point to things in the written testimony, and we will be sure to take a look at that. So, okay, first we will call Pat Murphy from the Miller Group to the podium. Thank you for being with us. Welcome to our committee.
We good? Everyone here? Chair and members of the committee, thank you for the opportunity to speak with you today. My name is Patrick Murphy. I'm the Chief Revenue Officer for the Miller Group. I work with child placement agencies across the country on issues of risk, insurance, and liability. I'm here today because Kansas child placement agencies are facing a crisis that threatens the stability of the entire child welfare system. They cannot afford, or in many cases, they cannot get coverage they need. This crisis is not because of their poor operations. It is a result of the fundamental shifts in our legal environment today. Shifts have made this category of risk essentially uninsurable to the private marketplace. The 3 reasons that are driving this: unlimited tail risk. The federal government several years ago, and many states have adopted and have made changes to their statute of limitations. The unintended consequence of doing this has put insurance carriers on the hook for a lot of liability that they weren't planning on it. So now today we have all these changes, and we have insurance companies saying, we don't know what claims are going to come out of the woodwork. That's not how insurance carriers work. They like predictive models. So one of those changes has created this position we are in today. The second one, and you may have heard this term as nuclear verdicts. Today we're going to say explosion and jury verdicts. Across the country, verdicts in institutional abuse cases now routinely exceed $10 million. And in some states and in some instances, they've reached hundreds of millions of dollars. The insurance carriers now must price for the worst case scenarios because they can't predict these claims. The third reason we're here today is liability untethered from control. What that means is agencies that are now being sued for incidents that occurred after their involvement ended, or for actions of third parties that they do not direct or supervise. They're being held liable simply because they were historically associated with that child, even though they have no direct contract or contact with that child anymore. They're being pulled into lawsuits because they had some interaction with that child over time. Again, insurance carriers cannot predict that.
Okay.
Cut my time in half, so I'm trying to go
Sorry.
fast.
Yep, if you could, you have about maybe 20, 30 seconds.
Why House Bill 2551 is the solution. It brings contracted child placement agencies within the Kansas Tort Claims Act for work performed under their contract. This simply aligns liability with reality. These agencies operate under state direction, court orders, statutory mandates, and contractual requirements. Under the Tort Claims Act, accountability remains, access to courts remain, gross negligence and intentional wrongdoing are not protected. What does change is that the liability becomes defined and predictable, just like it is for other state-directed functions. Predictability is the only way to restore insurability. Agencies are not asking for immunity. They're asking for insurability. And this bill helps create some stability in the insurance marketplace. Thank you
Okay.
very much. May I answer any questions?
I think we'll take questions at the end of the proponents. If you can stay, that would be great. Okay, we'll now have Linda Boss from KVC. Welcome to the Judiciary Committee. This is a little bit different. Glad to have you.
Yes, thank you, Chair Humphreys and members of the committee. Linda Boss, president of KBC Kansas. We are a child placing agency as a subcontractor for the Department of Children and Families. I'll keep it short in my time limit. I just want to hit a couple of highlights. In many states across the country, the state organization, such as Department for Children and Families, is the entity that's child placing agency. They license, they recruit, they train, they oversee, they support families who are temporary caregivers for children in foster care. In Kansas, while DCF licenses foster homes, they subcontract with organizations called child placing agencies to do the recruiting, the training, the supporting. In essence, the responsibility is subcontracted out. But as a CPA, we don't receive the same protections under the current Kansas tort claims. So what we're asking for is really not just to continue to have the responsibility that we have, but to be afforded the same protections as a state organization would be. So I have 4 benefits to this. One, it's protecting public funds. We're all working on contracts and grants that are the price and the reimbursement for that is set on day 1. And we can't go to the state on year 2 and say our liability insurance has skyrocketed. We have to maintain that cost ourselves. So if the cost goes up significantly, that means cuts in other sorts of programming directly to kids and families and staff, which is not what the public or anyone else wants. So for example, for KVC in the last 9 years, the cost of our liability insurance has gone up by over $1 million. And that is cost and expense that has to come from other places in our budget. The second is predictability, and this feeds into that same point. We plan our budget anticipating what the costs are going to be, but as you heard from the Miller Group, you don't have to be involved in a lawsuit to reap the negative repercussions from what's happening in the industry. The expenses go up every year for liability insurance, and sometimes they have gone up as much as 200, 300, 400% in a single year. The third is to encourage services to continue to stay. Organizations that are at risk for these ballooning expenses will unnecessarily or sometimes in a cautious fashion pull back services to kids and families to be able to have funds available to cover liability insurance. And the last one is just to have stability in this industry. We've seen the number of insurance carriers available to nonprofits continue to shrink while the amounts for those insurance policies continue to go up. And in other states, we've seen it where there are no insurance carriers who are available, and that's not the marketplace that we want here in Kansas.
Okay, thank you so much. And you can stay for questions, right?
Yes.
Okay, that's great. Thank you. Okay, we will now have Amy Harmon from Calm Foster Care. Amy, welcome to our committee.
My name is Amy Harmon, and I'm a licensed master's level social worker that's practiced for more than 30 years, and I serve as the CEO of a small CPA agency called Calm. Ask me on the side and I'll tell you how we got the name Calm, but it's a cute story. But what I'm here to express is what impact this will have as a small agency. We are a small team in a local community, and we've been performing this work for 13 years. And we currently serve 50 families that we license. We are directly contracted with DCF and KDADS to provide licensing work for foster homes. We sponsor about 50 homes at this time, and what we do exceptionally well is we carry a niche for families and children that have high medical needs, complex behaviors, and other challenging needs. The state actually often, and our partners with the CMPs, reach out to us because of our family's experience. Most of our families have been with us for 9 years. Many families have been fostering for 30 years. So where this has an impact is our highest expense operationally is with the cost of having insurance coverage, if we're able to have that. And because of the work that we do, it comes with a lot of risk. Sorry, my glasses on. Our liability insurance, as I mentioned, has always been our largest operational expense, and we must carry it to be able to stay in compliance with our state contract. Over the years, we have begun to see an increase from 8 to 20% annually. More recently, we experienced an increase from 40 to 66%, and this past year alone, we had an increase significantly of 136% just to remain insurable. This nearly tripled us from last year. These dollars don't benefit our children. They don't benefit the support we give to our foster parents. They do not increase the safety or the quality of our care. It's only just to keep our doors open. So we would like to invest our limited resources where they belong in our children and families, and not escalating insurance premiums and trial lawyers at this time. I'd be happy.
Okay, you'll stand for questions if people have questions. Great, thank you. It's good to meet you. Okay, and last we have Crystal Hedrick from the Children's Alliance. And welcome to Judiciary Committee, Crystal.
Thank you, Madam Chair. It's nice to be looking straight at you instead of to the side. My name is Crystal Hedrick. I serve as the CEO with the Children's Alliance of Kansas. We're a trade association representing the private nonprofit providers delivering child welfare services across the state. So our members provide a variety of services, but it's typically to the most complex and high-risk circumstances that we have in terms of child welfare. So foster care, family preservation, reintegration, adoption, and then other child welfare services. Oftentimes they fall under a child placing agency, but we're in support of this bill because it really makes a narrow but important clarification to the Tort Claims Act, just by extending coverage to these child placing agencies that contract with the Secretary for Children and Families and do work on behalf of the state. You heard today a lot of the implications. I just wanted to highlight a couple of things, and people that you may not be here in the room, but you may have heard about over time. Wichita Children's Home is one of our members. They provide a variety of services in the Wichita area, serving kids who are victims of human trafficking. When law enforcement go to a scene and they realize that there have been children involved in an accident, the first stop that they go is to Wichita Children's Home. Wichita Children's Home has had an increase of 112% in professional liability and 195% in umbrella coverage, despite never having a claim. These are important programs and services and providers in our state that we are very much at risk of losing if we don't make a shift. We're also at a time in child welfare where the acuity of our youth is much more high level for a lot of reasons that we're also addressing. But you heard Ms. Harmon talk about the types of children that they specialize in serving. We think about young kids coming into foster care as a result of injuries that they sustained because of abuse and neglect in their home. Some of them, it's truly a life and death situation. And our foster families and these agencies are stepping up in those high-risk circumstances, and we need to offer them some protection to stabilize these rates for them. So I'm happy to stand for any questions if the committee has them. Appreciate your time.
Okay, thank you. That was on the nose. Okay, committee, we're going to ask one question. I have in my mind set aside, we have 3 bills we're hearing today, certain amount of time for each one. If we have time, I will call on you to ask a second question. We're going to start with one question from committee members. And if you could formulate your question, before, just before you motion to me that you want to ask a question, I would really appreciate it so that we can get as many questions asked as possible from as many of the committee members as possible. Did you have a question? Representative Schreiber. Have you formulated your question? Just kidding. Okay, Representative Schreiber.
Thank you, Madam Chair, and thank you all. And I guess anyone could answer this, but I was trying to get a feel for if you would know, if this becomes law, how much money that saves on your expenses between what you're paying now for insurance or liability insurance and what it'd be if it was limited to $500,000.
Thank you for the, thank you for the question. I don't think we can actually predict the savings. I think the intent is today these agencies are being pulled into lawsuits for things that they really didn't have any part of. So I don't know if I can give you a savings, but what I can tell you is the insurance companies don't insure things that they don't know. And that's what they feel this industry has become. We can be sued by anybody at any time. There's no control. So I think that the intent of shifting part of this into the tort is to say, if we didn't do anything wrong, you can't sue us. If we are negligent, you can absolutely sue us. So only time will tell on that.
Okay, and just, that was Pat Murphy. Just from now on, if someone asks a question, if you'll just introduce yourself when you come to the podium. Yeah, I didn't ask you to do that, Pat, but did that answer your question as much? Okay, all right, Representative Bohai.
Thank you, Madam Chair. May I ask the question? Well, any of the proponents can answer it, but my question is this. What have insurance premiums gone up in the past 10 years? If we can get, like, is it 100%? Is it 200%? Is it 500%? My question is about that. Thank you.
Sorry, Crystal Hedrick of the Children's Alliance. I don't have premium increases for everyone, but I do have some here. St. Francis Ministries has been at 232% increase since fiscal year 20. Cornerstones of Care, 131% increase from 25 to 26, and overall a 235% increase since 2022. Wichita Children's Home, which I spoke to, is 112%. Calms has been 136% in a single year.
Representative Carmichael.
Thank you, Madam Chair. My question is for Mr. Murphy, the Chief Revenue Officer of the Miller Group. Mr. Murphy, your written testimony describes evolving liability theories, and you described new or novel theories of recovery that are exposing your insureds to liability. Can you give us some examples of published cases that I could look to see where these miscarriages of law or novel theories have been occurring, or give me specific examples here in Kansas where such judgments have been rendered?
Pat Murphy with the Miller Group. Since most of these cases have been settled out of court, the insurance companies, for the most part, have stopped going to trial on these cases for the last 5 years. So there's very little to point to give you exact examples. One of the things we see, and here's a real life example. A child placement agency puts a child into a foster home. They do their case management, they're following up, they're making sure their paperwork's in order, their I's are crossed, their T's, everything. That child runs away, and that child drowns in the neighbor's pool or pond. We had nothing to do with that. However, we are the ones being sued. So over the course of this past year, my office was dealing with 9 child deaths. 6 of those child deaths, the agency did not have anything to do with it. It was not on their watch, but they were the ones being named in the suit. So that's about as much as I can give you today.
File a motion for summary judgment. Thank you, Madam Chair.
Representative Osman.
Thank you very much, actually, Mr. Murphy. I think this might be something for you, or maybe even just as I listen to the opponent testimony as I try to formulate through. But I'm just trying to figure out, like, you've given, I understand why this legislation is being brought forward, the unpredictability, the uninsurability, I completely get that. I'm trying to understand the flip side, because you've given an example of, say, hundreds of millions of dollars worth of potential damages that can come out of trial. So what do you see as if this bill were to go through, what would happen to that particular piece of liability? I mean, would it just shift to other clients, or it shift to other people? Or how would that go about? I'm just trying to figure out, is your concern that the amount itself is unjustified, or is your concern just on sole liability within your purview?
Pat Murphy with the Miller Group. I believe that there are many states right now considering like changes, right? I believe it's going to provide the stability that the insurance companies are looking for. As we all know, insurance companies, particularly in commercial insurance, they like a lot of the same types of risk. So the reason they like a lot of the same types of risk is you can look at the past to project the future. An HVAC contractor has there's only a number of things that can happen, and they can look back to project what's forward. They can't do this in that industry today. There's no predictability. Now they can project, yeah, we're going to have an abuse claim. We're going to have a big pop here and there. And that's what their analytics and their actuaries and all of those folks, that's how they determine rates. But today, based on the lawsuits we've seen over the last 10 years in this industry, it's the Wild West. And that's why the carriers have made the decision not to go to trial anymore and to try to do everything in their power to settle out of court. So what they're pricing for today is worst case scenarios. We have literally 3 insurance markets that will continue to write child placement agencies in the state of Kansas. And one of them is not on good terms and will probably be pulling out of the state of Kansas, which leaves us with 2 options. In order to get the standard markets back in here, we have to give them some predictability. And today we just don't have it.
Representative Sappington.
Thank you, Madam Chair. And this may be for anyone except you, Mr. Murphy. So I'm wondering, are there requirements for riders in this liability coverage, like maybe stipulations from state agencies that you feel like you are paying for that are unnecessary? So almost the flip side of the coin. Are you paying for coverage that you feel like you don't need to be paying for, serving no purpose?
Anybody?
Thank you, Madam Chair. Crystal Hedrick with the Children's Alliance of Kansas. We'd have to gather some information on that and report back to you.
Okay. Yep. Thank you. If you could. All right. Anyone other? Representative Barrett.
Thank you, Madam Chair. And could we have Pat come back up here, please? Hey, thank you for your testimony, Pat. I guess my question would be, I want to run a scenario past you, just make sure that they would still be responsible, the agency would still be. So let's say contract agency A has an employee that goes rogue. He goes off the rails and, God forbid, abuses a child. Let's say that there was a previous complaints against this employee that maybe the agency didn't act on. Maybe there was a criminal history check, something was wrong because they were negligent in that portion of it. Even if he did something that was outside the scope of his employment, they would still be responsible, correct?
Pat Murphy with the Miller Group, absolutely they'd be responsible and subject to prosecution.
Okay, thank you, Madam Chair.
Okay, thank you, committee. I think we'll go ahead now and hear from our one opponent. But just so you know, there's 3 written-only proponents: Matt Stevens from St. Francis, Justin Horton from Cornerstones of Care, and Chris Conrad from Conrad Insurance Group. So we will go ahead now and hear from Richard Boudin, attorney. I don't know if I said your last name wrong. I'm sorry. You can correct us. Welcome to the committee. You have about 2 minutes.
Thank you, Madam Chair. My name is Richard Budden. I'm an attorney at Schamberg, Johnson, and Bergman, here on behalf of the Kansas Trial Lawyers Association. You guys, what you really need, you need evidence of what the reason for these rates increase is. Is it lawsuits? Studies typically show that these premiums go up with the rise and fall of the bond market, which is where insurance companies have most of their investments placed. That's what academic study tends to show. Is it because of lawsuits? If so, is that because of a significant number of cases where children have been harmed because of the actions of these CPAs? That's what this committee needs to know. If that's what has happened to increase premiums, then why would we give immunity to these companies? I want to give a little bit of background on the KTCA. The revisor did an excellent job. But generally, the state of Kansas has sovereign immunity under the English common law rule that the king can do no wrong. In 1979, the KTCA was passed, waiving sovereign immunity in some cases, but maintaining it for certain governmental conduct. As was stated earlier, there's 24 categories where immunity is still the rule, and that discretionary function immunity could arguably cover virtually everything that a CPA does, okay? Was it a hiring decision? Was it a placement decision? Are these not discretionary judgments where some amount of judgment is involved? So arguably, there's immunity. This bill is asking to give KTCA immunity to all of these CPAs for virtually everything they do, okay? Even when it claims not subject to sovereign immunity, the KTCA caps damages at $500,000. For a second, I just want to keep in mind, there's winners and losers with every policy. Here, the winner is obvious. We've heard from those folks. The loser would be Kansas foster care children who are already vulnerable, coming from a background of neglect and abuse, and have now been injured as a result of a CPA's conduct. They are the victims. They now probably don't have access to the courtroom doors. If they do, it's subject to a cap, okay? Keep in mind the industry we're talking about. In 2018, child welfare activists brought a class action against the providers, the CPAs, because kids were sleeping at the offices of the CPAs. They were lacking mental health support. There was a consent judgment agreed to in 2020 that brought this system into court oversight to end those practices. I've recently represented a child who was sexually abused as a result of their placement. I've recently represented the mother of a child who died because they were allowed to elope from a placement. And meanwhile, the CPA, who knew of multiple elopements by this child, was looking to find a placement for them where they would have even less supervision. I've never heard of somebody being sued because they were just at some historical point in time had conduct with a child. That's what summary judgment is for. If there's a claim based on that, it's gone quickly. One last point I just want to...
You need to wrap it up.
I'll wrap it up.
Okay, great, thanks.
This bill is not constitutional. Under Section 18 of the Kansas Bill of Rights, it promises that every injured person shall have remedy by due course of law. There are cases from the 1950s and 60s where charitable organizations or organizations supporting hospitals were given either statutory or judicial immunity, and the Kansas Supreme Court says you cannot do that because it eliminates that remedy. And then, of course, if there's a cap involved, we know from recent cases, the Hilburn decision, that violates Section 5 because these claims were allowed against private entities when the Kansas Bill of Rights was accepted in 1861, when the state became the state of Kansas. This bill would be struck down as unconstitutional. Thank you, and I'll take any questions you've got.
Okay, thank you. Just out of curiosity, I didn't catch where your law firm is.
Kansas City, Missouri.
Kansas City, Missouri. Okay, thank you.
I live in Shawnee.
Okay. And committee, what questions do you have for Mr. Budden? How did you say it?
Budden?
Budden. Do you have any questions for Mr. Budden? Representative Barrett.
Thank you, Madam Chair. Thank you for your testimony. I guess my question is, can you provide some examples of, they don't even have to be something that's actually happened, just examples based on your expertise of what cases would potentially no longer be able to sue an agency if there was any kind of wrongdoing?
Sure. So these agencies, they have care workers who meet with placements every month by statute. And if they hire someone who, let's say, has a history of sexual misconduct, all right, well, was that a discretionary decision that you made to hire someone? Well, it's not automatic, so it's arguably discretionary. You could hire a sex offender to meet with kids monthly, and if they abuse someone, you're immune because you used your discretion in hiring. That is a possibility.
Representative Carmichael.
Thank you, Madam Chair. Earlier in our discussion, we talked about, does this legislation shift the burden to pay these claims from the private insurance agency to the taxpayers of the state of Kansas? Could you respond to that question, as we didn't have an answer earlier?
Absolutely, it does. So if a child is a victim of sexual abuse, they're going to have a lifetime of psychiatric, psychological damages, and that care is going to have to be paid by somebody. If there's a lawsuit with a recovery, that money is set aside into a fund for that minor until they are an adult, and it can be used to pay those expenses. If that is not there, if these companies are immune, if there's a damages cap, then that gets shifted over to Medicaid most likely, or the state tax dollars paying for that care in the future.
Okay, thank you. I have one last question before we move on. So I am reading that maybe almost a decade ago, the Kansas Legislature included the Kansas Community Mental Health Centers into the TORCH Act. Have there been lawsuits? Has there been any challenge to that it's unconstitutional that they were added in? Do you know?
Not that I'm aware of. I don't know one way or the other.
Okay. Okay, thank you. Okay, committee, I don't think we have any neutral testimony. We have one opponent, written only, Michaela Sheldon. And seeing no others that want to speak, I will close the hearing on House Bill 2521. Thank you, everyone who came for this one. Okay, we will now open the hearing on House Bill 2613. And we have a new reviser that's going to give us a bill brief. Donica, thank you for being with us.
Thank you, Madam Chair. Donica Short, Office of Reviser of Statutes. HB 2613 concerns the Crime Victims Compensation Board and fees for conducting examinations of persons who may be victims of sexual assault. Section 1 amends the provision of KSA 65448 related to the fee chargeable for conducting an examination of a victim. Subsection H, as amended in HB 2613, provides that the Crime Victims Compensation Board shall establish and pay the fee for such an examination. That subsection further provides that the board shall be reimbursed such fee. Current statute provides that the Department of Health and Environment establishes the fee, while the county where the alleged offense was committed pays the fee and shall be reimbursed. Section 2 adds a provision to KSA 7304 to allow the board the power to adopt rules and regs necessary to carry out the provisions of KSA 65448, and Section 3 adds a provision to KSA 747317 to allow monies in the Crime Victims Compensation Fund to be used for the payment of those fees. House Bill 2613 would take effect on July 1st, 2026 after publication in the statute book. I can now stand for any questions.
Okay, thank you. Committee, do we have any questions for Donica? Okay, seeing none. You did a good job. Thank you. Okay, we will now hear from our proponents. Kristen, I'm so sorry. You're going to have to tell me your name, from the Attorney General's office.
Thank you, Madam Chair. Members of the committee, my name is Kristen Chugala. I am the Division Chief of Victim Services with the Attorney General's office. Thank you for the opportunity to speak before you today in support of House Bill 2613. You have my written testimony, so I'll just highlight a few pieces here for you and offer some information in support of this bill. So this bill will transfer the financial responsibility of paying for sexual assault examinations from the county where the crime occurs to the Crime Victims Compensation Board. Currently, there are 29 states who do use their crime victims compensation programs to pay for sexual assault examinations, plus 3 more states that use a sort of hybrid option for victims who obtain an unreported examination and choose not to engage with law enforcement. So the majority of states do use their compensation programs to pay for such examinations. Transferring this to Crime Victims Compensation provides consistency and a streamlined process for hospitals who are responsible for ensuring that the bill gets to the correct county, which can be confusing, especially if it's happening right on the county line or a victim was transported from one place to another. It also, counties require different information to document and establish that they are responsible for paying this fee. And then it can get even more confusing when a victim is assaulted in Kansas, but travels to another state to obtain examination. Maybe they're going home where they feel safe and comfortable and want to get their examination. So this would just provide consistency in a streamlined process where we have one centralized location that's reviewing. We'd only be responsible for determining the assault happened in the state of Kansas, so fewer boundaries to navigate with that. It would help the hospitals with that process as well as victims of crime.
Okay, thank you, Ms. Shugawa. If you can stay for questions, we have one more proponent that we'll hear from and then ask questions. Okay, now on WebEx, we have Richard Samaniego from the Crime Victims Compensation Board. He's the chairman. Richard, did you make it to the committee?
I did. Thank you,
Okay.
Madam Chair.
Okay, great. Welcome. Glad to see you.
Appreciate the opportunity to appear remotely from Wichita in support of the bill. I'm not going to repeat a lot of what Kristen has relayed to the committee, but I did want to point out some really the streamlining victim services element. Kristen and I were at a conference and hearing from different states that are handling it this way, and it just made sense. We looked at each other, we're like, why aren't we doing it this way? And so this is really an effort to make victim services better. If you recall, in 2024, the legislature broadened one of our statutes to one of the elements of being approved for compensation is reporting to law enforcement. In 2024, that was broadened to also a victim obtaining a forensic medical examination within 7 days. So building on that, that is one of the items that the board has to look at. Of course, subject to a good faith exception for not doing that, but that is one of the elements that we look at, and it just makes sense for the victim to have one set of services helping out in streamlining those the compensation element of it, and also the requirements for eligibility. As Kristen mentioned, as the board, we hear a lot of confusion from victims because they're dealing with so many different people. So anytime there's an opportunity to help a victim have one face that's helping them through the process is also very, very important. The other major point I'd like to point out is that this is matching funds paid for by offenders. And so that is the sole purpose. We receive funds from offenders, and so statewide, the compensation fund would be able to pay for those services to victims, but also make rules and regulations on how that process is to work, and making sure that the victims are getting the services that are appropriate. And I'd be happy to stand for any questions if the committee has any.
Okay, thank you, Richard. I appreciate that. Committee, we now will go to questions for our in-person proponents. What questions you have, Representative Carmichael?
Thank you, Madam Chair. It may be best to ask this question for Mr. Samaniego. Can you hear me, Richard?
Yes, Representative.
Okay. What I understand here is that currently counties, i.e. law enforcement, are paying for the cost of these sexual assault test kits. And what the board proposes to do is instead have the Crime Victims Compensation Board pay that expense out of the money that was intended to help and compensate the victims of sexual assault and other crimes, rather than being paid for by law enforcement as it is now. I must misunderstand something. Help me.
That's correct. The main point is the streamlining. We have a lot of counties in Kansas, and sometimes it is confusing on the county's end on how to do the reimbursement and whether it does get reimbursed, best practices and how to reimburse, and that is. I guess the best agency to do that would be the Crime Victims Compensation Division. They're the ones that their sole mission is to handle compensation for victims. And since one of the eligibility requirements that the legislature set was the victim obtaining a forensic medical exam within 7 days, that's just one additional opportunity to set up a claim for that victim. Because they'll be able to receive that information at that time to set up their claim. And as you know, there's a 2-year deadline to get compensation. And so we will make that ensures they will have a claim set up. So in a sense, it is a victim-centered proposal.
Okay, thank you, committee. Any other questions? Representative Osman.
Thank you very much, Madam Chair. Representative Carmichael actually touched upon pretty much the various thing that I wanted to discuss, but I guess I should ask the revisor maybe this question. So last year, I think that we increased the total funds in the Victims Compensation Fund, Crime Victims Compensation Fund. Do you know how much that has been increased to? And this bill does not further increase it. And so any compensation that is made out of this from this bill would come out of the net pool amount that's totally there.
Madam Chair, Representative, so for the actual numbers, we'd need to ask a fiscal person, so we can work with our colleagues across the table for that. But to your second question, the bill does not make any appropriations. So there's no adjustment to funds in this bill.
Representative Vaughn.
Thank you, Madam Chair. My question is in a similar vein, and possibly it's been answered, I'm not understanding, but so the bill says so essentially the Crime Victims Compensation Board establishes the fee, and then it says the Crime Victims Compensation Board the payment. Okay, so essentially, and then the Crime Victims Compensation Board has to pay the fee. So is it coming from their fund, or could the Crime Victims Compensation Board establish the fee and then charge the fee to he mentioned the offenders, for example? Like, is there a way to set up that fee structure in that way, or would it automatically come out of the Compensation Board's statutorily established fund, as was asked earlier?
And who was that question directed to?
Whoever feels they can best answer it, including the revisers, if that's appropriate.
Okay, Ms. Shugala. Mm-hmm.
Thank you. So the fee that gets set would be established by the board. That's a common process across other compensation programs. And so that would be done in consultation with other states to make sure that we're not higher than everyone else or lower than everyone else, that we're in the median. Those funds would come from the Crime Victims Compensation Fund. No appropriations are needed. Our fund is fully funded by offenders throughout the criminal justice system. So it's funded by restitution, fines and fees at the district court level. There's some funds that come in from the Kansas Department of Corrections as well, and that funds our program.
I'll come back to you just a minute. Representative Williams.
Thank you, Madam Chair, and you can stay and answer this question. I was reading through the opponent testimony, and it's a provider, and they say they pay those costs out of pocket, so moving the payment may delay their reimbursement. How long does that take for that payment to be reimbursed?
So this is a different process than our current process. And that's some of the revisions that are within the bill that establishes that this is paid and they're not subject to our other eligibility requirements, which is what takes time because we have to get police reports and we have to get information and we have to establish all these things. This is separate. This is a direct bill process. So this would move very rapidly. The hospital would be able to direct bill us immediately and we would be able to process that within 30 days, probably is my estimate.
Okay, great. Thank you, Madam Chair.
And you might as well say, because my question too is, I think this was mentioned, but if there's a 75% federal match, is that correct? Is that for the examinations? I mean, it's always been there, or that has more to do with the Crime Victims Compensation Fund?
Thank you, Madam
Yep,
Chair.
mhm.
That is specific to the Crime Victims Compensation Fund. We are the only ones that are able to receive that 75% match. So it's for every state dollar that we spend for victims of crime through our program. And this would be eligible for that. So if we spend our state fund, our compensation fund towards that, then we could receive 75% match from the feds towards those costs to keep the program moving forward and not draining.
Okay, thank you. Representative Vaughn, you have a follow-up?
Madam Chair, just to follow up on my question, I think the question we're all trying to get at is, so if these fees are coming from the fund, do you anticipate that that will diminish the ability to pay victims the compensation they're due ultimately? Or do you feel that there is enough money in the fund to pay for both?
Thank you, Representative Vaughn. I would not support a bill that would drain our funds. So I am confident that this will not drain our funds, that we are stable. We can incorporate these costs and continue to pay victims as we have been, and continue to pay the expenses that are put before the board.
Representative Curtis.
Thank you, Madam Chair. And what is that fund balance?
I do not know at the moment.
Could we get that?
Yeah.
Or we might be able to get it from Jordan. Jordan, go ahead. You have a comment?
Thank you, Madam Chair. I just sent an email to our fiscal analyst who's assigned to the Attorney General's office, so I'll send a follow-up to request that amount.
Okay, thank you. We'll get that amount. Okay, any other questions? Representative Barrett.
Thank you, Madam Chair. Thank you for your testimony. Can you just talk on, in addition to law enforcement, who else may get this reimbursement? Who may, sending these women in for testing?
Thank you, Representative Barrett, members of the committee. So right now, that fee is paid directly by, sometimes it's a sheriff's office, sometimes it is a county or district attorney's office, sometimes it just goes straight to the county budget. It's just the county, so every county handles it differently. We've heard from some rural counties who have a single fee, a single kit, the exam that they're having to pay for at $725, and that is a burden on their budget, that they are having difficulty figuring out where to pull that from and asking for help on how to figure that out. And the statute says the county has to cover it. So that's another reason why we came forward with this idea.
Madam Chair.
Okay, committee, no more questions? Okay, thank you so much. And we do have quite a list of written only proponent testimony. Jay Hall from the Kansas Association of Counties, Ed Klump. We have someone from, wow, a private citizen with lots of letters behind her name. Shayla Knickerbocker, Michelle McCormick, Mary Stolps, and Jandy Head. So, and then we have one opponent written only testimony, Katrina Alvarado, a nurse, sexual assault nurse examiner, a private citizen. So please take a look at those written only testimonies. We don't have any neutral or other opponent testimonies, I don't believe. So with that, we will close the hearing on House Bill 2613. And we will open the hearing on House Bill 2614. And again, we will have our reviser, Donica, give us the bill brief. Thank you for being with us.
Thank you, Madam Chair. Again, Donica Short, Reviser of Statutes. HB 2614 concerns the Crime Victims Compensation Board and exceptions to the confidentiality of records. KSA 747304E provides that all records and information given to the board in the Crime Victims Compensation Division to process a claim shall be confidential. HB 2614 adds 2 exceptions to that confidentiality requirement. First, HB 2614 provides that records and information may be obtainable from the board upon a finding that the records given to the board were not previously available to an agency investigating or prosecuting child abuse or neglect. Upon such a finding, the board may disclose such records and information necessary to assist in such investigation or prosecution. Second, HB 2614 provides that records and information may be obtainable from the board upon a finding that the records and information given to the board are wholly or partially false or fraudulent. Upon such a finding, the board may disclose such records and information to a law enforcement agency responsible for investigating or prosecuting such false or fraudulent records and information. HB 2614 would take effect on July 1, 2026 after publication in the statute book, and I can now stand for questions.
Okay, committee, what questions do we have for the revisor about House Bill 2614? Okay, seeing none, we'll go ahead and go to our proponents. Okay, we have again Kristen Shugala from Crime Victims Services Division. Welcome back.
Thank you, Madam Chair and members of the committee. I'm Kristen Shugala, Division Chief of Victim Services, and in that capacity, I also serve as Director of Crime Victims Compensation. So House Bill 2614 provides for some very narrow expansions to our confidentiality requirements. We propose this cautiously because victims' confidentiality is of the utmost importance to us. One of those areas is in records that we receive for child abuse and neglect claims. We receive information from lots of different sources, from law enforcement, prosecutors, DCF, hospitals, et cetera. And so we have a view of maybe a situation that not everyone does. And so we modeled this after the State Child Death Review Board's recent changes, I think maybe 3 or 4 years ago, where they had a similar expansion so that if they saw information, evidence of child abuse that law enforcement didn't have, for example, that they could provide that document to them. So at the moment, if I see that, I can't provide that information to anyone. I'm not allowed to under our confidentiality requirements. So the intent of this is specific to child abuse claims where there's mandated reporting, and in very rare circumstances, but it would be narrow in scope so that we could try and fill in some of those cracks that just exist in our system sometimes. The second portion is to ease our ability to engage law enforcement to open an investigation if we believe fraud has been committed against our program. So it doesn't happen often that we see those things, but we have seen an increase in the last 6 to 8 months of suspicious documentation. And I suspect we're going to continue to see that in the age of AI and the ability to modify documents. We do our very best to prevent that, and I believe we do a good job of that. But should there be a time that funds are given to someone and then we find out that that was under fraudulent circumstances, this would make an easier process for us. At the moment, our legal counsel would have to file an action in court petitioning the judge to subpoena our records so that we could take them to law enforcement and engage. So, thank you.
Okay, thank you. And if you'll stay, we probably will have some questions afterwards. Okay, well, welcome back, Richard Samaniego on WebEx. Hey, Richard, you there?
Thank you. Thank you, Madam Chair. Can you hear me okay?
We can.
Okay. Richard Samaniego, Chair of the Crime Victims Compensation Board. Again, I won't repeat what Kristen has just indicated to the board, to the
Richard,
committee.
do you want to turn your camera on? I mean, you don't have to, but we can hear you, but we can't see you.
It is, I'm trying,
Okay,
but it's not turning on for some reason.
That's fine. Go ahead. Didn't mean to interrupt. Thanks.
No problem. Thank you.
Go ahead.
Okay, thank you. So, so I want to reiterate that this is a very narrow, really narrow focused bill. And the board really just needs guidance from the legislature of what they want us to do with certain cases, that we either find more information that would help, or we find information that is concerning, like the fraud that Kristen has indicated. The staff reviews all of these cases and police reports from all over the state, as does all 3 board members every single month. So we see it, like Kristen said, from another angle, but also we're a third and fourth eyes on all of this. And so when we come across this information, the board really just would like to know what to do when we find this additional information. the board is very cognizant of mitigating factors in mental health and circumstances, and we take that, that information very strongly in deciding what to do. But with regard to the fraud, if we see, really concerning documents and they're repeated, we need to know if there's, if the legislature would like us to refer that for further investigation, or if it's really the intent is to keep it completely confidential and to just deny the claim. But again, this is something that every board member sees these documents and they read these reports, but they also hear from the witnesses, and information comes to light, and more information is always better. But this is narrowly focused to those and modeled, as Kristen said, off of the Child Death Review Board's changes. And I'd be happy to answer any questions.
Okay, thank you so much. Richard, so just a quick question. You mentioned, is the board 3 people? You're the chair and there's 2 others on the board. Is that true? Is that correct?
That's correct, Madam Chair.
Okay.
It's a 3-board member. The chair is always an attorney. We also have one with a mental health background and one with law enforcement background.
Okay, thank you. That's helpful. Okay, committee, what questions do you have for our proponents? That would, Representative Vaughn.
Thank you, Madam Chair. This could be for either Comfrey. I guess I understand the child abuse and neglect provision. I'm contemplating more the fraud provision. I'm just wondering if you could maybe give an example, like a hypothetical example of what like the Crime Victims Compensation Board might discover that local law enforcement wouldn't, because I would generally think that investigating those matters would be a local law enforcement issue, and that issuing or going about getting a subpoena to request that information from you all would be the normal process. So I'm just trying to think through why that's necessary, if you could maybe give us an example.
Thank you, Representative Vaughn and members of the committee. So that provision is for if a victim has presented us with false documentation and we've issued a payment on their behalf. So the fraud has been committed against our program, against the state. And it's difficult to have law enforcement investigate that to determine the fraud did occur. So I have to carefully discuss that because I have to maintain confidentiality, but there are a couple of benefit areas where that is more apt to occur than others because medical bills are medical bills. If you get those directly from the provider, you can verify. Excuse me. Relocation is one of them where we help victims move to safe locations. Leases come to us from all different sources. And we have seen a lot of those with concerning information on them that do not appear to be authentic. And so usually we can spot that before money goes out the door. And so it's in the situation where we're not able to catch it that we're concerned that we would like to have law enforcement, who are the experts in determining if fraud has occurred, for us to be able to engage them easier if that happens.
I'll come back to you if no one else. Are there any other questions from the committee? Okay, Representative Vaughn, go ahead with a follow-up.
Thank you, Madam Chair. And then the reverse of that. So if you pass that information on for them to investigate further, they found that it was in fact not fraudulent or correct information, would that be sent back to you so that then you could issue the payment, for example?
Thank you, Representative. Yes, absolutely. If law enforcement is able to determine that it was legitimate and not suspicious, wasn't fraud, then yes, we would be able to either issue that payment or end the investigation if no crime occurred.
Okay, any other questions for the proponents? Okay, thank you so much. And by the way, you didn't introduce yourself, but just in case someone's only listening and not watching, that was Kristen Shugala that answered that question. Okay, committee, we don't have any other proponents. We don't have neutral and we don't have any opponents on House Bill 2614. So I will close the hearing on House Bill 2614. Okay, thank you everybody for getting that done in a great manner. We now are going to go to working bills. First bill we're going to work is going to be, and this is a bill we heard last year, and I had indicated to you all that we would have a substantial amendment for that bill. So we'll just go ahead, Jason, if you could remind us what the bill is, and then we'll get to the amendment after that.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So HB 2357 is a bill, as you mentioned, you heard last year. This is about housing. The main provision has to do with court records in eviction actions where the underlying rental agreement is governed by the Landlord-Tenant Act, that those will be sealed for certain periods. They will be expunged. Records related to those will be expunged after a certain amount of time. Certain violations of the act would be subject to the Kansas Consumer Protection Act penalties and enforcement. Certain eviction actions would be required to go to mediation. And I think that pretty much covers the broad strokes of the underlying bill.
Are you done? Okay, sorry, I was like, okay, thank you for that. Okay, committee, I think, hopefully you all remember this, but I think it'll be helpful when you see what the amendment is. So do we have amendments on this bill? I'll call on Representative Williams.
Thank you, Madam Chair. I have the very large amendment. If it was, I think I'd mess the bill up. While it's getting passed out, I will let the revisor explain.
Yep, go ahead, please.
All right, thank you, Madam Chair. Jason Thompson again. So I'll start with the easy part. There's some technical cleanup because this is a carryover bill. So there's some certain adjustments like to the title, where statutes are now KSA or SUP or not. So you can just kind of gloss over those and I'll hit the main substantive changes. You'll see the large box on page 1. So the current bill there in lines 26 through 29 talks about how after the court seals the file, the records are only available to certain persons. The amendment proposes striking paragraphs 1, 2, and 3 there and inserting instead, this would now be paragraph 2, and these would be A, B, C, D under that. So the records would only be available to the court and court staff, any party of the case, and their attorneys if they're represented, a person with a valid court order authorizing access, and a person authorized to access under paragraph 3, which is the next paragraph in the box. The court would allow more people to access the file if they affirm to the court in writing or electronically that they are an attorney other than a party's attorney or acting on behalf of an attorney. They're a party included in the court file, a party included in the court file gave written or verbal permission for them to access the file. The person is only accessing the record for certain purposes, such as providing legal advice or evaluating whether it's suitable for mediation. And then the last one is they're not accessing the record for commercial purposes. Because that's an and, all of those would be required. So, right, they need to be an attorney, someone in the file gave permission, they're only accessing the record for one of these purposes, and they're not accessing it for commercial purposes, other than potentially providing legal advice. So that's an and, all of those are required for that special access. All right, that's the first one. Page 2, then you see some changes about what a default judgment or judgment entered in favor of the plaintiff means. Judgment in favor of the plaintiff, the first box there on page 2, it means for monetary damages or possession or both. So it sort of clarifies what that means. Line 7, currently it just says the court shall not unseal a case. This would say the court shall decide at the time of judgment not to unseal a case. So it tells you when the court should do that. Line 11, replacing victim of domestic violence with a statutory term, protected person from, these are folks that can have their property, a special address, I believe, is what you get under that section. It's related to domestic violence, but it is a protected person definition, more accurate to what the proponents were trying to cover with the provision, I think. And there's a couple of changes in the middle of page 2, including attorneys. And then what's that last change in the middle? Automatic sealing by the court pursuant to this section, and shall not request that applicants or tenants disclose a sealed or expunged eviction filing. This is what agencies and management companies cannot do. This would add that they shall not request disclosure of sealed or expunged eviction filings. You'll see there's a number of strikes in subsection D2. They're in lines 23 through 27 of page 2. This is to clean up the penalty provision, the remedies provision. So it still says that any violation is deemed a deceptive or unconscionable act under the Consumer Protection Act. It's still subject to those remedies and enforcement. And I think we determined this sentence wasn't necessary to effectuate that purpose. It's still subject to consumer protection. That's the main point of that. Then at the bottom of page 2, it's probably easier just to tell you what it would say. Except as otherwise provided in this subsection, a defendant in an eviction action in which the underlying rental agreement is covered by the Residential Landlord-Tenant Act may make an electronic filing for an expungement at no cost. The court shall grant an expungement if 3 years have passed. Since judgment was entered in such action, the defendant shows that monetary obligations of the judgment, if any, are satisfied, and the defendant has no additional judgment entered in an eviction action. And that should be in which the underlying rental agreement is governed by the Landlord-Tenant Act within the 3-year period. You'll see in the underlying bill, this was automatic expungement. Very simple phrasing, and this has been fleshed out a lot more about how that process would work, I think, in consultation with the court system. Then you'll see in the bottom of page 2, there are a couple strikes to 2-year period. Those would be 3-year periods under the bill. So instead of waiting 2 years for expungement, you would now have to wait 3 years. That is consistent throughout that provision there at the bottom of the page. And then on the top of page 3, we add a provision that the Judicial Council shall develop a form to be used for obtaining expungement. So a fairly routine clause we have for forms by the council. You'll see that I had to remove all of current section 2 because you amended that section last year. And so I have to put that section back in as it exists in current law because the Constitution requires you to show all of the current law in the bill. So we're just doing our job, making sure you have a constitutional bill. And it's reinserted as attachment A, which is on the back of the balloon. You can see there's no difference. It just puts it in that you can seal this file. Provisions of the section about requiring certain findings to seal the case don't apply to eviction actions in which these rental agreements are involved, and under section 1, where it's already got a sealing provision. So this is a carve out from the general rules about sealing. We just had to put the whole statute back in there to do that. Then back to page 4, the underlying bill. I'm going to say most of that is cleanup. It looks like we were clarifying where to in which, and we were clarifying, oh, there's one substantive change I should point out. Line 30, bill required the court to order mediation unless it found it would not materially aid the parties materially. This change in line 30 and 31 would be the court shall consider mediation unless the court finds that mediation would not aid the parties materially or is impracticable. So there's a couple more discretionary things for the court there rather than the order. And then the bottom of the page, the continuance that is required under the bill that was not time limited, there is a 14-day continuance added in the box on the side there in line 42. I think that covers everything. Happy to answer questions if I can.
Okay, thank you, Representative Williams, for a little more explanation.
Thank you, Madam Chair. I know this is a lot, and when we heard this bill last year, it was a lot to unpack. So what Representative Howerton and Howell and then all of the shareholders came together to come to this agreement. And so I did just want to preface that before we talked and asked questions.
Okay, any other questions first for the reviser? Do you have any questions about the amendment for the, Jason, the only question I have is on page 2 about kind of starting in line 20, the Consumer Protection Act. That, how does striking what you struck change the substance?
Madam Chair, we had a long discussion about whether that language was needed or was more confusing. And I think we determined in this bill and in other bills like it, we've been using just violations of this section are deemed acts or practices under the Consumer Protection Act that are subject to the remedies and enforcement provisions, period. These are in addition to other requirements and remedies provided by law. That was enough to get us under the Consumer Protection Act. And that middle sentence that's being deleted is kind of redundant. It states something that's, once you get over the Consumer Protection Act, yes, you can bring a private action, and yes, you can, basically it's just not necessary, I think was the conclusion, and the proponents decided it was better to not have it in there because the other language that's left gets to the same conclusion and doesn't confuse the issue about what happens when you go to the Consumer Protection Act and use it for enforcement.
Okay.
So we agreed.
Yep.
We've drafted a couple others that use that cleaned up language.
Okay, that makes sense. Okay, committee, what other questions do you have? Representative Carmichael.
Thank you, Madam Chair. I must admit, this is a lot to digest here, and I really do appreciate Mr. Thompson pointing out that the big strike at Section 2 is only there because we have to republish it, if you will, in the attachment, because that about lit me up. This seems to make some sense to me, what we're doing here. I can see some of the problems that I had with this bill initially appear to have been addressed, so I'm pleased with that. My specific question, though, to the carrier is, when you say all the shareholders or stakeholders have been consulted on this, does that mean everyone who testified as a proponent last year is in agreement with these changes, or are there people who were not consulted, or people who were consulted and don't agree with what we have in front of us? I just want to feel comfortable in going down this road.
I can't give into specific detail who the all of the shareholders were. I do have the testimony pulled up from last year, and there was only neutral testimony from the Chief Justice, Special Counsel and the Chief Justice, which had the issue of the domestic violence issue, which is addressed, and then the caseload issue. And I think that, I know that there was some negotiation on the 2-year
Right, the 2 to 3 year on the expungement, which is of concern to me also.
yes, and so the 3-year was kind of a compromise there. I may defer to Representative Bohai on that negotiation, if you don't mind.
And I appreciate your patience, Madam Chair. I want to make sure that we don't have people who were proponents who are upset about what we're doing here. That's what I'm trying to do.
Representative Bohai.
Thank you very much, Madam Chair. A couple of things. I had been working on an amendment, I thought, regarding this bill to have the time go from 2 years to 3 years. I thought this balloon amendment was going to have a 5-year time frame on that, and I thought that was too much, so I asked for 3. So that's probably my fault with how things were going. I'm very happy that this got to 3 years as opposed to 5. I do think that when the conversations were happening, when they were talking to the different people that were against it, even though they weren't necessarily testifying last year, there were still people that were not in favor of how it was written, and they wanted 5 years. So I was going to actually bring an amendment to say, instead of 5 years, taking it back down to 3 on the expungement. Also, I will say I was one of the people last year that said it couldn't be an automatic expungement. I didn't want that. I wanted there to be a process where they had to, they didn't have to go into the court, but they needed to at least put forth the effort to request an expungement. So the electronic filing portion of that was my request, and that's part of the reason why that's in there, so.
Madam Chair, just before we go, there's one other thing that did concern me.
Is your microphone on?
I just need to get a little closer.
Okay, go ahead.
Thank you. At page 2, down near the bottom here, lines 30 through about 41, it looks to me, though, like we took this from what was originally a 2-year waiting period before expungement and made it a 3 as opposed to a 5 back to a 3. Can you help me?
Right, I think originally I thought this amendment was going to have 5 years in it. So I was going to ask then to amend it to 3, and that's not what happened.
Okay, I think I understand. Thank you all. I appreciate your help.
Representative Williams.
Thank you, Madam Chair. And to address your proponent, all of the proponents who were proponents on the bill last year are all still proponents with this amendment.
Excellent, thank you.
Committee, do you have any other questions? Okay, so right now we're voting on the amendment. And would you like to move the amendment? I think you explained it. Did she move it or just?
Madam Chair.
I didn't think so either.
Madam Chair.
Well, we need first just the motion.
I move that we amend House Bill 2357 with the Williams Amendment.
Second by Representative Curtis. Okay, so just last chance for some discussion on the amendment. Representative Curtis. Oh, I thought you were saying you wanted a second. Okay.
No, absolutely, I do. As somebody who's worked for 8 years trying to get expungement legislation passed in this committee, I certainly do support this legislation. I think it's thank you for bringing it forward. I think it's a good move for us to do. So thank you.
Okay, any other discussion? Okay, would you like to close?
I close and move my motion.
Okay, thank you. So committee, you've heard the amendment to House Bill 2357, the Williams Amendment. All those in favor say aye. Opposed, no. Okay, so the amendment is now on the bill. Do we have any other amendments for House Bill 2357? Okay, seeing none, I'll take a motion for, yes, I'm sorry. My preference would be to have it be a sub because it's so marked up. I think it would be more clear if it was able. So it would be the, you concur. Okay. Yes, great. We're all in agreement. Okay. Yep. So,
Thank you, Madam Chair. I move that we pass House sub for House Bill 2357 as amended, or is it not? However, I need to say it favorably for passage.
Do we have a second? Representative Bohai seconds. Okay, committee, now discussion on the bill. Any? Okay, then Representative, you may close.
Thank you. I close and move my motion.
Okay, you've heard the motion to pass the sub for House Bill 23, or House sub for House Bill 2357 favorably for passage. All those in favor say aye. Aye. Opposed, no. Okay, we have passed House sub for House Bill 2357. Yes, you would like your affirmative vote, and Representative Vaughn, affirmative vote. Anyone else? Okay, very good. Okay, thank you. Committee, we are now going to move to House Bill 26. Okay, hang on just one second. Yeah, okay. Okay, committee, we're now going to look at House Bill 2444. And if we could get our revisor to just give us a reminder about that bill.
Thank you, Madam Chair. Jason Thompson, Revisor's Office again. House Bill 2444 is the bundle of items related to folks who have committed repeat violations while on release for prior felonies. So it does a number of things. First, it provides jail credit when consecutive sentences are imposed, shall not apply to more than one case. So this deals with the issue between prosecutors and defense about how jail credit is determined in the Court of Appeals cases. You may recall that testimony. Second, it creates special sentencing rules when a felony is committed by certain offenders while on probation, parole, post-release for a prior felony. And third, it requires secured minimum bonds for certain defendants who commit a new felony while on release for a prior felony, unless the court makes certain findings. That's the very high level.
Okay, thank you. And committee, what amendments do we have for House Bill 2444? Representative Williams.
Thank you, Madam Chair. I have an amendment.
Okay, and would you like to explain that while they're passing it out, or you want to let everybody look at it? Because it's substantial.
Kind of briefly talk about it, and then I'll let Jason explain. So we have House Bill 2444. I took the contents of House Bill 2611, which both involve KSA 22-2802. So my amendment largely inserts the language from 2611 into 2444 and incorporates changes to address some of the concerns raised by the opponents.
Okay, thank you. Committee, take a look at that for just a minute, and then we'll ask for questions. Yes. Okay, maybe it would be helpful if we had a reminder from the revisor what 2611 was.
Sure. Thank you, Madam Chair. Jason Thompson again. 2611 is the bill relating to release prior to trial. It is the one that provided limitations and restrictions on releasing a person charged with a crime on their own recognizance. It was the one that limited PR or OR bonds, depending on your terminology, to folks that met certain criteria listed in the statute, ranging from lawful resident of Kansas all the way to not charged with certain felonies. And that was 2611.
Okay, thank you. And just to confirm, on page, I mean, it says 15, but I think it's like 4 of the amendment, that big balloon is what was in 2611, basically?
Madam Chair, I believe the bulk of that is in 2611. There's a couple things I would probably mention that are not when we get to the explanation point.
Okay. Okay, I think we're to the explanation. I think that's you.
Sounds good. Thank you, Madam Chair. If I could just go in order because it'll help me stay on track. So on page, it's just page 2 of the balloon, but it's page 13 of the bill where you have the special sentencing rule that's part of KSA 21-6804, the sentencing grid statute, right? Because this is double C, it's 13 pages in. That's why I cut the other 12 or the 11. You'll see that what is added is while an offender was in custody for a prior felony or all the current language in the bill. So what this would do would add someone who commits an offense while in custody, not just out on release for a prior felony. And that's the same at the bottom of page 13. It adds it to that special sentencing rule for limiting departures in 21-68-18. That same rule that's in the bill would apply to someone who's in custody for a prior felony when they commit the current felony. So that's what those two changes are for. And then you get to the big box on page 15 of the bill, and you'll see the subsection C in the underlying language, lines 22 to 26, is struck, and this new box would go in its place. I think paragraph 1 is the part that's not really in 2611, and I wanted to highlight that because there was a lot of talk about misdemeanors, what we're doing with misdemeanors in the bill. or in that bill, I suppose, more than this one that was focused on felonies. Paragraph 1 would make clear if a person is charged with a misdemeanor, the appearance bond is executed with sureties unless the magistrate determines in the exercise of their discretion that requiring sureties is not necessary to assure the appearance of the person at the time ordered or to assure public safety. That's almost exactly the current law, just made clear that it applies to misdemeanors. So if you compare current law to that, it's almost identical. So that would kind of continue current law with regard to misdemeanors. And I don't know that that was clear from the prior bill. Paragraph 2 then is what happens if you're charged with a felony. That would kick in with the, you have to have a surety unless the magistrate determines by clear and convincing evidence after a hearing at which the person charged is present that requiring sureties is not necessary to assure the appearance of the person at the time ordered or to assure public safety. Further, prior to releasing a person charged with a felony without a surety, the magistrate has to determine after that hearing that we just talked about whether the person meets the following qualifications, and those are the same qualifications that were in 2611. So lawful resident, no prior felony, no prior history of failure to appear, no detainer, no extradition, not detained for a violation of probation, not charged with the felony DUI, and not charged with the drug severity level 1, 2, or 3 felony. And then subparagraph C says that if the magistrate determines the person does not meet one or more of the qualifications listed in subparagraph B that we were just talking about, there is a presumption that the person is either a flight risk or that such person's release would endanger the public. That should be a period right after that. Such presumption may only be overcome by clear and convincing evidence. Prior to ordering a release of such person without a surety, the magistrate shall make a written finding on the record that such person is not a public safety risk and not a flight risk, and specify which of the qualifications listed in subparagraph B that such person meets. And I would say this is the other part that was not in 2611. Aspects of it were, but this makes clear that there's an additional written finding required by the magistrate to go ahead and go without a surety if one or more of those factors is present in the offender's case. I think after that, there's a couple cross-reference issues. Page 16, just making clear that subsection C, what we were just talking about, and Q, which is new, both apply as an exception to the PR/OR bond subsection. And then on the final page of the balloon, page 18 of the bill, there's some language in the lines 14 and 15 that's struck, so that would read the person's criminal history is, so let's see. So if the person was on release when they committed the charged felony and their criminal history score was A, B, C, D, or E, except as provided in Q2, right below here, the court shall set a secured appearance bond not less than the amounts that are provided here. Then you can see the 100,000 for the lower level felonies is changed to 50,000. The 250,000 for middle level felonies is changed to 100,000, and the top level felonies from 500,000 to 250,000. So they're all cut in half from what was in the bill. And then rather than the exception to the rule that was provided in paragraph 2, that's all stricken and replaced with the paragraph in the box. Such bond shall not be reduced or modified downward unless the magistrate determines by a preponderance of evidence at an evidentiary hearing and makes a written finding on safety risk and not a flight risk. At the evidentiary hearing, there's a presumption that the defendant is both a public safety risk and a flight risk. And you may recall this is similar to the language added last year, right above in subsection P. So if you want to kind of compare that to the current law, right above this new language, it should line up pretty well with something you just did last session. I think that covers it. I know it's a lot.
Representative Schreiber for a question.
Yeah, that was a lot, Jason. Thank you. My question, I'm curious, last week on the floor, we passed 254, and in there was a presumption that someone that, can't remember the wording, but was undocumented, and they crime, then there was a presumption that they could not be released on their own recognizance. But it seems like this added section would conflict with that. I'm not an attorney, so you'll have to help me here. It seems like in one case, there's no discretion on the part of the judge, but then in this section, this added section, there is.
Jason?
Madam Chair, I'll do my best to answer it. The main answer is it's not law, so I can't account for it in this bill. I can't account for hypothetical law, right? Right. Until 254 is law, I can't draft around it. So this assumes the current law. And one of the criteria is that the person is a lawful resident of Kansas. So to that extent, it's consistent, but you're right. If there's a strict prohibition in that bill and there's a more general, the magistrate can make certain findings and get out of the bill, you might have a discussion about which one should prevail and apply in a certain case. There's a lot of statutory interpretation that goes into that about which one's more specific, which one's more general, which one passed last, which it gets confusing, and we would probably want to clean it up if both were to become law. So we'll keep an eye on that.
Yeah, and I think that's a good catch, and it's something that we've talked about, and so I'm glad that you brought that up, just so that we could have that explanation. But it is something that would need to be cleaned up, as Jason said. Okay, Representative Carmichael, and then Vaughn.
Thank you, Madam Chair. Just to stay within the questions. I can see that we reduced some of the amounts of the required bond. That's at page 18. But as far as what lands you in jail or allows you to bond out, do we have major substantive changes in this amendment as compared with the original bill? And the reason I ask is I'm looking at the bed impact assessment, which we're going to have to talk about at the appropriate time. But I'm trying to figure out, is the bed impact still valid, or have we made changes there? And I know that's beyond some of the revisor's role, but help me as best you can.
Madam Chair, Jason Thompson again. So yes, I can't really speak to the analysis that the good folks at the commission do. So I won't go into that, but I think you'll be able to see sort of how this changed, and that might help you answer it amongst yourselves. Subsection C1, so the first provision on the box on page 15 is different from the other bill with regard to how you handle a person charged with a misdemeanor. I think there was some question during the 2611 conversation about whether misdemeanants had to be held and have this hearing before they could be released. And this makes clear that they're handled basically as they are under current law, that it can happen more in a streamlined way. And these new rules only apply to folks charged with a felony. Because a lot of that was not in this bill, I don't know that it'll affect the bed impact necessarily, because the only change in this bill with regard to bond was on page 18, saying that if the person was on release for a prior felony and they're now charged with a felony, these restrictions apply, and that doesn't change in the balloon. So the impact for this bill probably doesn't change. The impact for 2611 could change because we made clear misdemeanants are going to be handled differently than felons. I hope that helps clarify.
It helps. Thank you.
Representative Vaughn.
Thank you, Madam Chair. Going back to Representative Schreiber's question in regards to how it interacts with 254. So I think the misdemeanor would be different. So this is taking out the fact that it would apply to a misdemeanor. But the two things that I'm seeing that are very similar is this concept that someone has to appear so the appearance bond shall be executed with sufficient solvent sureties who are residents of the state of Kansas unless the magistrate determines after hearing at which the person charged is present. So the person has to be present in order for that to be charged. So they could be put in jail before that hearing, before it could even be determined if they would be eligible for an OR bond under these conditions. And then this concept that there's a presumption that such person is either a flight risk or would potentially endanger the public. Those are both very similar to what's in 254. The difference is that it's by clear and convincing evidence. So I'm wondering if we could get a definition of clear and convincing evidence from the revisers just to refresh us.
Jason, please.
Madam Chair, I'll try to be professor, as Senator Peterson used to call me. So very generally speaking, right, you've got levels of proof, right, that beyond a reasonable doubt, that's your criminal one, that's the highest. And this is clear and convincing is somewhat less than that. And the one below that would be preponderance of the evidence. So this is the middle level. There's not an exact definition. It's one of those nebulous legal terms, but it means more than just probable, or it means more than the preponderance, but it doesn't mean beyond a reasonable doubt. It's right in the middle.
I don't think he's answering because, and then you know, on the back page, there's also a time when we use preponderance. I don't know if you noticed that or not. So, yeah, that one is preponderance, and then in the balloon, it's clear and convincing. Okay, any Representative Osman?
Thank you, Madam Chair. So when 2444, the amendment was brought out, there was a quick comment that there were opponents to this. This sort of mollifies the opponents, but part of this is part of the amendment is 2611, and there was an opponent that was for both of them, 2611 and 2444, who basically said, I wrote in my comments, this will crush county jails if we implement 2611 into this. So I'm trying to figure out how this amendment is going to help to solve some of the opponent issues when this is going to, we're probably going to discuss prison bed space, but I'm trying to figure out how this is actually going to help solve the issue by combining two things that's going to help to blow up county jails.
I mean, yep, I can answer. Thank you, Madam Chair. And thank you for the question, Representative. I think one on page 16 where we kind of broaden out some of the concerns from the opponents and from members of the committee to not allow them to sit in jail over a weekend waiting for a required hearing to request a signature bond. We push that to only felony. And so that kind of creates those lower seriousness of crime criminals sitting in the county jails overnight or over the weekend. So I think it kind of, I don't know if, how much that dictates the prison bed space, but even this in-person hearing for a signature bond, in some cases wouldn't be had if a surety bond was granted.
Thank you.
Okay, any other questions before we go to discussion? Representative Curtis.
Thank you, Madam Chair. And did we get a bed count or a fiscal note on this? I was looking, I couldn't find it, so.
Yeah, 2444, yeah. Okay. Okay, so let's go to discussion. Representative Carmichael, you had already said that you had discussion, so I knew that you.
Yeah, I appreciate you allowing me to be heard. First, this is a whole lot of legislation to be observing or to be absorbing, let alone acting on in 10 or 15 minutes. And it's unfortunate that we're all in this situation. That being said, based on what I've been told about the impact of this bill, there are improvements. It sounds like that the at least intent of the maker of this amendment and those who work together to bring us to this point is to exclude misdemeanors from the scope of this legislation and just reenact the existing law about bonding out for misdemeanor. If that's not correct, I hope someone will correct me and let me know that I'm in error in that regard. But that appears to be an improvement. That is an improvement that impacts the county jail for misdemeanors, but it doesn't impact the county jail for felonies. We don't have a pretrial detention bed impact because we don't typically get those. We don't know for sure what impact this will have on the number of people held in a county jail for felonies while awaiting trial. Suffice to say, if you increase the bond and you make bond amounts mandatory and you limit judges' discretion, which I think in general is what we're doing here, that means less people are going to be able to bond out. Less people are going to get out on their own recognizance. It's going to take up more space in the county jails. We don't really know how much space it takes up. But what we do know is that the bill, at least 2444, is the largest bed impact statement that we have seen, so far as I know, this year in either corrections or the judiciary committees. This is a big deal. This is 225 beds in fiscal 2026. That's almost as big as the Wichita Work Release Center in downtown Wichita, which is about 250 beds. We know from the Corrections and Juvenile Justice Committee, what we've heard from the Sentencing Commission and the Department of Corrections is that we're within about 2 years of the state prison system being full. Dump this 225 beds on top of that, you're going to have to start talking about building another prison. And it's easy to be tough on crime when you sit here, but it's hard to be tough on crime when it comes time to appropriate the money to make a place to hold these folks. And if you don't do that, then you have prison overcrowding and you have felons who are turned loose because of violations of constitutional provisions regarding the Sixth Amendment, as I recollect. So be very careful. This really seems appealing on its face. We're going to lock people up longer, and that's going to make some people feel good. But you've got to then be prepared to spend the money to make a place to put them. And so far, I haven't seen this legislature be willing to do that. And for that reason alone, I won't be able to support this legislation today. I will continue to study it. Thank you, Madam Chair.
Other discussion, Representative Bohai.
Sorry, thank you, Madam Chair. May I ask the former representative a quick question about about his statement he just made? Because I thought I heard him say 2026, but I believe the impact study says fiscal year 2036.
If I said 2026, that was in error. It's 225 for 2036. It's 106 for 2027.
Okay, I just want to make
and
sure.
I may have misspoken,
Okay.
so I appreciate you. Here.
It gives us a little bit more of a runway
Mhm.
if the impact is 225 in 2036. I'm not saying that it's not still an impact, but maybe I misunderstood. I
Well,
apologize.
I appreciate that, but then when you said the former representative, and I thought, no, he's
Speaker, I
Yes.
apologize.
One who spoke previous.
yes.
I look forward to the day when I'm a former representative. Thank you.
Okay, any other discussion about the amendment? Representative Lewis.
Thank you, Madam Chair. I share the concerns of representative from Wichita, and I generally think that the Sentencing Commission does a good job of predicting these things. On the other hand, I've also heard from law enforcement, as I've worked on this bill, that they believe that the population that we're talking about here is relatively small, because they say that the thing they keep seeing is the same people over and over and over again come through the system. And so, I don't know. I'm wouldn't say I'm skeptical. I just have some questions about the predictions about the bed population. And if it's true, and I think it is, that law enforcement is seeing these repeat offenders come in and out all the time. The other benefit of this bill is that it will free law enforcement up to, pay attention to others, and their time will be freed up by this bill. So that's a fiscal benefit and a benefit to the, I guess, the esprit de corps of law enforcement, because I gotta think it's frustrating to go out and arrest somebody, and then the next week you're doing the same thing and seeing a revolving door. I'll be supporting the amendment and the bill. But I will say that we do have to take into account and think about prison population. And in fact, the corrections committee will be meeting on this Friday with 2 other committees to discuss the need for a new prison in Hutchinson to replace the 19th century prison we now have there. And I'm sure this issue of prison beds will come up at that point.
Representative Barrett.
Thank you, Madam Chair. Yeah, just to briefly kind of back what was just said there, both on the amendment and the bill, why I'm supportive of it is, it's hard to tell if you live in a really large city. Like if you live in Overland Park, Topeka, Wichita, you may, because there's just so much population, you're going to have numerous criminals work in that area. But when you look at like small towns, for example, like Coffee County, for example, we'll have small communities of 500, 600 people, and it's way easier to see that you'll have that one criminal. Like you'll have criminals that do small crimes, convenience crimes. Someone happens to leave a garage open and they steal something. But then you'll have those 1 or 2 individuals that are just chronically in and out. Like the minute he gets out, we have a stolen vehicle. Then, that same day. And you talk to any deputy in a small county, they can name those people by name in each little small town who are just continually committing crimes. So when they're locked up, surprisingly, cars don't get stolen. And they get out, breaking, entering, vehicle stolen. So I think it's very important to go after that very small few people that are committing a lot of these crimes.
Okay, other comments on the amendment? Okay, seeing none. Yes, motion.
Thank you, Madam Chair. I move the Williams Amendment to House Bill 2444.
Do we have a second? Representative Barrett seconds. Any other last discussion on the amendment on House Bill 2444? Okay, seeing none, all those in favor of amending House Bill 2444 with the Williams Amendment, say aye. Aye. Opposed, no. The ayes have it. The bill will be amended. Representative Carmichael? Nope. You don't want, sorry.
So, I'll be happy to take credit for my no vote, Madam Chair. Please place it in the minutes. I appreciate your courtesy. I was thinking about not saying anything.
Okay, wow, what do you, okay, anyone else on that? Okay, so now we have amended House Bill 2444, and now we're on the bill. Do we have a motion on the bill? Representative Williams? Well, I was going to just do the motion first. Let's do the motion first.
Thank you, Madam Chair. I move that we pass House Bill 2444 as amended favorably for passage.
Do we have a second? Representative Sappington seconds. Okay, now let's discuss House Bill 2444 as amended. Representative Carmichael.
On the bill, I'm very cognizant of what Representative Barrett said just a moment ago. And it's been going on for as long as I've been around the courthouse and probably long before that. Repeat offenders, frequent flyers, our regular customers. And yeah, we do need to figure out some way to put those folks out of business. But I just can't take this big a file and this big an amendment and put it all together in my mind and figure out that this is the right solution to the problem, especially when I'm looking at a bed impact with no reasonable likelihood, as far as I can tell, that we're going to be forthcoming with the money to build a new prison. And even if we were, that wouldn't make more room for these 200 and some odd people that are coming in. That's what we need to replace the beds that we've already got that are as I say, from 2 centuries ago, it seems like. So I can't support the bill, but I certainly respect those who want to see tougher penalties for frequent flyers, repeat offenders. They hurt people, they steal money, they're a problem, and they do need to be in jail. But I can't support this approach to fix that problem. Thank you.
Okay, do we have other discussion on the bill? Representative Vaughn?
Thank you, Madam Chair. I mean, it's a lot to take in and kind of process, but I think generally my takeaway is with both the underlying bill and the amendment that was added. I mean, I think a key part of what's happening is we are penalizing poor people by increasing bail minimums in 2444 and then increasing the requirements around being able to receive an OR bond and increasing the number of surety bonds that are ultimately going to be administered. I mean, people who can pay for surety bonds will get out and, not have issues with these new requirements. But people who can't afford them, your everyday Kansan, are going to be penalized. And I don't think that's fair. So I think there are a number of reasons that I'm a no on this, but that would be one of them.
Thank you. Any other discussion on House Bill 2444? Representative Williams.
Thank you, Madam Chair. I appreciate the work of this committee and getting to the bill where we have it. I do want to address, the previous representative's comments on punishing poor people and not allowing them to be able to be released back into the community. I think what this bill does, it sets accountability for our judicial system. It provides for the community to know that there's accountability when someone needs to appear to court. And I think that's important for not only the victims, but for our community to know that as well. It puts accountability not only on the courts, but it puts the accountability on the person who committed the crime. And so I am pleased with the product that we have, and I believe that it will help protect not only our neighbors, but it will help protect this from happening again in a situation of what happened in Douglas County with William Klinger, he failed to appear on 3 separate bonds, both surety and signature bonds, and was released out on a signature bond when he struck and killed Elsa McRain. So I just want you guys to remember that. And after we heard House Bill 2611, Elsa's mom reached out to me, and she wants to make sure that this never happens again to her, to someone's daughter, niece, sister, mother, and encourage the committee to support this House bill. So thank you, Madam Chair.
Do we have any other discussion on House Bill 2444? Representative, you may close on your motion.
Thank you, Madam Chair. I close and move my motion.
Okay, committee, you have heard the motion to pass favorably House Bill 2444 as amended. All those in favor say aye. Aye. Opposed, no. The ayes do have it. We will ask the secretary to record Representative Carmichael's no vote. Anyone else? Okay, so we have passed House Bill 2444 favorably for passage. We are now going to take a look at House Bill 2610. House Bill 2610. Okay, and we'll ask our advisor to give us a quick reminder of what this is about.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So this is the bill about limiting the use of a summons instead of a warrant for the arrest of a defendant to misdemeanor crimes, and also requiring that any bond set on a warrant issued after a failure to appear in response to a summons shall not allow release on the defendant's own recognizance. So the current law that you can use a summons instead of a warrant is preserved for misdemeanor cases, but that is prohibited for felony cases. You would have to use a warrant. And the bill also continues the current law that if you fail to appear in response to a summons, a warrant issues, and then adds that such warrant will not allow release on recognizance.
Okay, do we have any amendments to House Bill 2610? Anybody? Okay, seeing no amendments, we will now discuss House Bill 2610. Anyone have any comments? Okay, Representative Carmichael.
Madam Chair, I don't always have to go first, but if I don't go sometimes, we may just move on. So summonses are used to hail into court people who are at low risk. Theoretically, when you get a traffic ticket, you'll find oftentimes up the top, summons and notice to appear. In lieu of taking you to jail, you get a summons. And they're also used for felony cases. You may be watching a lot of the folks federally who are getting arrested on various charges of one kind or another. Sometimes the FBI goes in and kicks down the door at 6 o'clock in the morning. That's because those folks, they get the equivalent of a no-knock warrant because they may destroy evidence or there may be a flight risk or other things. But for folks who've been working with the prosecutor, they haven't been able to come to terms, they're going to have to go ahead with the prosecution without an immediate plea deal, then a summons is what is used to hail people into court but not throw them in jail pending trial. People who are charged with crimes are cloaked in a presumption of innocence. I believe the principal purpose of this bill is to make more money for the bail bonding industry, and I do not want to be a part of that. Thank you.
Thank you. Other discussion? Representative Lewis.
Right, so I've been a prosecutor. I've dealt with a lot of law enforcement, and really the issue of whether you use a summons or a warrant is something that you make on a case-by-case basis, and it's something that I think is best left to the discretion of those who are prosecuting the case. A warrant is much more involved. It's time and expensive, and to just set forth a rule as this does, a summons shall not be issued instead of a warrant in a case of a complaint alleging commission of a felony, I think just straitjackets law enforcement in a way that's not helpful to law enforcement. So I'm opposed to the bill.
Representative Williams.
Thank you, Madam Chair. I just want to bring the committee's attention that all this bill does is bring the same amount of discretion that the judge or the magistrate has now that the prosecutorial or the prosecutor has. So it just brings the two in line with each other.
Does anyone have any other discussion or questions for that matter? Representative Carmichael.
Two quick observations. If it's broke, don't try to fix it. And the second of those is, no, I don't even want to go down that road. If it's broke, you don't need to fix it. Thank you. Not broke, you don't need to fix it. It's a long day and it's only Monday. Thank you.
Sorry. Anybody else? Okay, seeing no other discussion, do we have a motion on House Bill 2610?
Thank you, Madam Chair. I will say that it is broken. We have seen a misuse of summons, especially in Douglas County, like I stated in my testimony. So with that, Madam Chair, I move that we pass House Bill 2610 favorably for passage.
Do we have a second? Representative Bohai, second. Okay, last chance for discussion on House Bill 2610. Anybody? Okay, you may close. Representative.
Thank you, Madam Chair. I close and move my motion.
Okay, committee, you've heard the motion to pass House Bill 2610 favorably for passage. All those in favor say aye. Aye. Opposed, no. No. The chair is in doubt. I'll have to ask you to raise your hand. All those in favor say aye. Or sorry, don't say aye. Raise your hand. Okay, opposed? Okay, I counted 10 affirmative and 6 noes, and so the bill does pass favorably for passage. Representative Carmichael would like his no vote recorded. Anybody else? Okay. All right, committee, I would like to get to House Bill 2535. I'm thinking that this should go quick, but you never know. So 2535. Jason, could you give us an update on House, or a refresher on House Bill 2535? It's not. Did I say the wrong one? 25. Yes, it's 2535. I don't know what I said. That's wrong. Sorry. 2535. Isn't that what I said? Okay. 2535, TNVR. Mm-hmm.
All right, thank you, Madam Chair. Jason Thompson, hopefully one last time. HB 2535 is the bill that says certain portions of the crime of cruelty to animals do not apply to a person who's catching feral cats, to provide vaccination, spaying or neutering, and returning the cat back to the location where they were caught. That's the trap, vaccinate, neuter, return, TVNR that they were talking about. And it's just 2 provisions of animal cruelty relating to abandonment or failing to provide food and water to, an animal that you're releasing. Those would not apply to you if you're running one of these programs or catching cats as part of one of these programs.
Okay, thank you. Do we have any amendments on House Bill 2535? Okay, seeing none. We'll take a motion on House Bill 2535.
Thank you, Madam Chair. I move that we pass House Bill 2535 favorably for passage.
Do we have a second? Representative Vaughn seconds. And do we have any discussion on House Bill 2535? Representative Lewis.
I actually have a cat house in my backyard.
Thank you for that information. Yeah. Okay,
To be more specific,
yes.
I actually do have a neighbor that catches feral cats.
Oh.
And spays and neuters them, and is renting a house in my backyard to house the feral cats. So I want to protect my neighbor and myself from any allegation of cruelty to animals. So I'm going to support the bill.
I had no idea this was so close to home for you. Thank you for that personal testimony. Okay, anyone else have any discussion on House Bill 2535? Okay, seeing none. Representative, would you like to close?
Thank you, Madam Chair. I close and move my motion.
Okay, you've heard the motion to pass House Bill 2535 favorably for passage. All those in favor say aye. Opposed, no. The bill passes unanimously. Okay, we're going to do one more. We're going to do House Bill 2519. House Bill 2519. I'll let Jason explain it, even though it's the regular bill we have every year.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. And this is the bill requested on behalf of my office related to the Open Records Act, asking you to review and renew exceptions that were enacted or substantially amended 5 years ago. It's pursuant to KSA 45-229, and you have a whole packet of information about those statutes that you're asked to examine.
Do we have any amendments on House Bill 2519? Okay, seeing none, we'll take a motion on House Bill 2519.
Thank you, Madam Chair. I move that we pass House Bill 2519 favorably for passage.
Do we have a second on that? Representative Bohai seconds. Oh, Sweely, sorry. Sweely. Okay, is there discussion on House Bill 2519? Representative Carmichael, then Vaughn.
Thank you, Madam Chair. I have a note on my file that says needs amendment to preserve disclosure of Child Death Review Board. And we may have taken care of that in some other fashion. I see somebody shaking their head no. I don't even know what my note is about, but it sounds like other members might know.
Representative Vaughn, can you, or do you, is that your question also, or do you have the answer to the question? It's a question. Okay, why don't you go ahead?
Thank you, Madam Chair. I think, so this was, there was a confidentiality exception where the Child Death Review Board could disclose information to local entities who are investigating child deaths. And this, I think, was a request made by Wyandotte County due to the death of a child, a really egregious death of a child. And so I just wanted to pose the question for any members from Wyandotte County if they'd heard anything from local officials about wanting to maintain this exception. I think the Child Death Review Board was in favor of allowing the exception to lapse because in the last 5 years it had not been utilized. But I didn't know if perhaps Wyandotte County might have given a different answer.
Representative Curtis.
Thank you, Madam Chair. I asked that question and they did not seem to have any concern. So I guess they don't have a concern anymore.
Thank you for that information. That's very helpful. Anyone else? Okay, seeing none. Would you like to close on your motion?
Thanks, Madam Chair. I close and move my motion.
Thank you. Committee, you've heard the motion to pass favorably House Bill 2519 favorably for passage. All those in favor say aye. Aye. Opposed, no. Okay, then House Bill very meekly passes out favorably 2519. Okay, thank you, committee, for getting all of that done today. So appreciate it. I do want to tell you that one bill that was on the schedule for tomorrow has been changed to Wednesday. So tomorrow we possibly will hear, we'll only hear 2 bills, but we might work any bills that we have heard so far. I would love to give you a list. I don't have it in front of me right now, but just know that if anything that we have heard so far, we might work tomorrow. And then Wednesday, we are going to hear 4 bills, but hopefully not work anything is what the plan will be. And then Representative Lewis, you have a question?
I'm a little unclear. So I'm looking at the agenda for tomorrow.
Yeah.
We have 3 bills. You're saying we will work or won't work? What are we going to work tomorrow, if you know? I'm sorry. What are we going to hear tomorrow?
Yes, great question.
Yeah.
Sorry, I don't have my agenda in front of me. The one that we're changing to Wednesday is the one about the Court of Appeals, 2652. That's the one that we're changing to Wednesday because of a scheduling conflict. So, and you'll get an updated agenda, but just so I wanted to make sure that you all knew that. That one's not on for tomorrow, but it is on for Wednesday. And I will try to give you the bill numbers of anything that we could possibly work tomorrow. So, and I would also appreciate it this week as we're scheduling, what are we going to work, what are we not? If you know you have amendments on bills, I would really appreciate knowing just so that I can make sure that, you know, we have plenty of time and all of that. So I knew today that we had large amendments and whatnot. So, and that's very helpful as we do scheduling. So, okay, thank you for your great work, committee. Really appreciate every single person on here. We're adjourned.